Good morning, everybody. It is April 9th, 2024 at 11:32. Welcome to the Incarceration Prevention and Reduction Task Force Legal and Justice Systems Committee. I will begin with a land acknowledgement statement. Before we begin, we acknowledge that we are gathered on the traditional and unceded territory of the Lummi, Nooksack, Samish, and Semiahmoo people, who have cared for and tended this land since time immemorial. Truth and acknowledgement are critical to building mutual respect and connection across all barriers of heritage and difference. We begin this effort to acknowledge what has been buried by honoring the truth. We pay respect to their elders, past and present. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that bring us together here today. And please join us in uncovering such truths at any and all public events. So I would like to welcome to our new IPTRF chairs, Peter Frazier and Heather Flaherty, as well as Dr. Bertie Safford, to today's meeting. I will start with the first item on the agenda and then circle back to those individuals so we can have a discussion on ways they may be able to assist us in future meetings and what we want to see moving forward. So welcome. Today's agenda is a discussion on the new standards for indigent defense as adopted by the Washington State Bar Association. So in 1972, I believe, or somewhere in the 70s, they had these standards that they wanted to implement, the Supreme Court to implement. That didn't happen until 2012. Since then, there's been a lot of changes to cases and how they are proceeded with between prosecution and defense. And so there has been new caseload standards that were submitted by the American Bar Association. They were then adopted by the Washington State Bar Association, and they are currently with the Washington State Supreme Court to decide if they want to adopt them and how they're going to proceed. I believe right now it's kind of an advisory, but I'm going to let Maya take it away and give you a little bit more information on that. And I think Eric Ritchie and I will add to that, and then we can have a discussion on it.
We're probably just ripe for discussion, honestly, because I don't have a lot more information to add at this point. We're waiting to see what the Supreme Court will do with the recommendation from the Board of Governors from the bar. It could be that the Supreme Court adopts them as recommended. They could increase the timeline for implementation, which would give counties in the state more time to sort of sort out the funding that would be needed for these new standards. It's very difficult for me to even speculate about how it's going to roll out in Whatcom County at this point. And we don't know what the Supreme Court's going to adopt. So it's kind of, I don't know. That's where I'm at right now, is that it's a big nowhere, except that I expect change is coming and it's going to probably be really expensive. So
yes, very much so. So just to add a little bit into that, to give you kind of a picture of what the Supreme Court is looking at, is the current caseload standards are 150 felonies and 400 misdemeanors. What the intention is to go to July 2nd of 2025 to July 2nd of 2026. That would reduce caseloads to 110 felonies and 280 misdemeanors. And then 2026, it will go to 90 felonies and 225 misdemeanors. And then in 2027, it would go to 47 felonies and 120 misdemeanors. That's a 70% reduction in caseloads per defense attorney over the next 3 years.
to complicate that further, those numbers are for basically C and nonviolent B felonies. When you're talking about homicides or Class A sex offenses, they're weighted. And so when you get to the last stage of proposed implementation, where a defense attorney could accept 47 C and nonviolent B offenses. If they're getting sex offenses, they can get six cases. The amount of time contemplated, and this, the amount of time comes from that should be spent on that type of case comes from this RAND study, this national study that was published by the ABA. And it says that I don't have the numbers in front of me, but maybe it's like 300 hours should be spent on a sex offense case. Right now with our case waiting system in Whatcom County, we give each case is allocated 12 hours of work, which is absurd, really. And we give 3 case credits for a Class A sex offense, which suggests that a Class A sex offense would have 36 hours of work applied to it. That's also absurd. That's not realistic. Far more time than that goes into those more serious cases. But the amount of time that the RAND study suggests should be attributed to those cases is just far, far more. And, the quality of defense would be improved by having more time to work on those cases, but the numbers are kind of hard to wrap your head around from where we've been.
And to give you a little bit more history, and just going back just a little bit to when I started in the county in November, there was a large amount of individuals that were incarcerated that were unrepresented. So somebody gets booked in, they get screened for a public defense attorney by the clerk's office, Office of Assigned Counsel, and then our office will then route that individual's information to the public defender's office. Public defender's office looks at the case and says, hey, this is going to work, we're going to take it. Or they can say, actually, this is a conflict, we can't take it, or we don't have enough attorneys and we're over our caseload standards that are currently met, so it's overflow, and that's going to go to conflict attorneys. So we just started a brand new conflict office, which currently has 2 attorneys in it, which has helped. And then we also had to look at what are we going to do when there's conflicts with the conflict office, because that happens more often than most people realize. And so then we have to contract out with attorneys outside, and they also have to make sure that they're in compliance with the current caseload standards, and there's not enough of them as well willing to take the cases. So then you've got unrepresented people sitting in jail that have a right to an attorney, and then it's up to the judges to decide, what are we going to do with this person that keeps coming before us that has a right to counsel that doesn't have counsel? The judges can appoint from the bench. They don't really want to have to do that. And then when you do that, you have local attorneys that get a little bit angry that they've just been appointed by the bench, because that also takes away from cases that they're actually able to take privately. So you don't want to do that too often, and you want to make sure they're compensated. So there are good things about the proposal. I think personally, I think seeing a mitigation specialist and making sure there's a legal assistant and an investigator for public defense is great. I also think that defense attorneys should be able to have more time to dedicate, because as the director of the State Office of Public Defense, Larry Jefferson, in interview that was done recently, Maya sent that out, I think Jill passed that on. He was discussing how defense work has changed over the years, and we've seen the mandates for body cams, and we've discussed that before. It takes longer for the prosecutors to review the cases. It takes longer for defense to review the cases. So there is definitely a need and a change in how we're doing business. Whether or not the county would be able to, or the state would be able to find enough attorneys and to be able to pay those attorneys, what they're requesting for the Supreme Court to adopt is definitely a concern. And as Maya suggested, we don't know what the Supreme Court is going to do. But I'm going to let Eric chime in on that and then open it up for questions.
I don't have a whole lot to comment on this. I do expect that something will happen. I like Maya, know that the Supreme Court has been asking for some caseload standards for some time. They've been looking for some buddy to figure out what the standards should be. And they got that. They got that from the Bar Association. And I expect that the Supreme Court will adopt much, if not all, of what the Bar Association has recommended since the Supreme Court's been wanting some sort of recommendation. I can tell you a little bit more, and that is that our director of WAPA, that's the Washington Association of Public Defense, excuse me, of Prosecuting Attorneys, geez, he has had some contact with the Supreme Court Justice Yu, and she told him that they might be slowing their roll on deciding this issue, recognizing the impact to counties. Now, the impact to counties is going to be huge, and I shouldn't say just counties because it's going to be cities too. In fact, we're worried about the financial impact, but we're also worried that we're not going to be able to fulfill this, even if we had the money. Because who would we hire? We don't have enough attorneys out there right now. And anyway, this is a real problem. It really could. I mean, I expect it to be a big blow to the criminal justice system as a whole. I mean, it might just stop us in our tracks. That's all I got right now. I'm sorry for being doom and gloom, but that's what I see.
I mean, Washington is the first, as far as I know, the first state to adopt in a whole the recommendations of the AVA study. And, whatever our Supreme Court ends up adopting is likely to be pretty cutting edge, I have a feeling, nationwide. And so there is like a little glimmer of hope in that our most recent hires were from Alaska and Florida. I mean, we're already recruiting from out of state. And I think that Washington, as a front runner on this issue, we may be able to attract employees from all over the country because our caseloads will be so low compared to what is happening. There's states that have no caseload standards as it is. So, I think that will make us pretty attractive and give us some recruiting abilities, but still, like, the size by which we will be expanding is really hard to comprehend. I mean, even just, it's like, because then of course it impacts IT, it impacts HR, it impacts facilities, and we are very overburdened on those things as it is. So there's still massive ripple effects. One other thing about the number of attorneys that's contemplated just to do the work, that doesn't really consider the number of attorneys needed to supervise those attorneys, right? So if we, right now I supervise a lot of people. I have a lot of direct reports, like 20 some, which is too many. And that's something that I think we're trying to work to address within my office. But if we're to triple or even double in size, that means a lot more middle management as well, which means attorneys who maybe aren't on caseload, who are supervising and managing. So there's just so many build outs from it that I think the Supreme Court will hear comment on, and I think we'll hear some pretty rigorous comment on from a lot of stakeholders. And I don't know where it'll end up.
Thanks, Maya. Thanks, Eric. I see Darlene's hand up and then somebody in the conference.
Hi there. I was just going to say, I wholly support public defense needs. I really do. But as a court, I am very concerned, especially as a city court. We're no longer, I used to be in charge of all of our public defense. I no longer am allowed to do that for the Supreme Court. And so now our finance department is the one that gets attorneys. We already have 2 conflict attorneys, and it's not enough. we have cases that those conflict attorneys can't take because Bellingham's a small place and people represent victims and defendants. And so we have cases that we are struggling, the city is struggling to find public defenders for us. There's just a shortage. And I know that higher wages would be sufficient, but the real concern that I am hearing around the state from other courts is, where are you going to find those attorneys? Secondly, the financial impact. Third, as Maya pointed out, it's not just supervising those attorneys, it's all the support staff. It's the clerks, it's the courtrooms, it's, you know, it's all of that that has to be funded to go with it. And so I'm not sure what the answer is. I don't like to say that I have issues with something without proposing some kind of answer. But I think that imposing these limits in this short amount of time, I think will bring our justice system to a halt, because I don't know that it can be done. And that's my main concern. Not that it doesn't happen over time or that we can't address it in some way, but I mean, I'm hearing voices from the legislature that they're on a tight budget as it is this next time. And so where's that money going to come from? And if they're not willing to support it, how in the world will we be able to do that? And while we're trying to help defendants, which is always good, I wonder in the long run if it's going to hurt them if they can't even have an attorney. And so I don't know how it'll all wash out, but that's just some of the things, some of the issues that I'm seeing with it. And for everyone's sake, I hope that we at least get a slower start to give everyone a time to figure out how they can practically make it work.
Yeah, and thank you for that, Darlene. And I think that there can be proposals for alternatives to the RAND study, but it's difficult because they are just made up out of whole cloth. You know, I mean, they're not based on any research or study, right? All we have is the RAND study that says these are the amount of hours that should be attributed to these types of cases. We could say, well, that's great. We're not willing to go that far. We'll just say, well, we'll reduce them by a third and just pick a number, and maybe then pay for a state study similar to the RAND study that will take years to complete and would require timekeeping by public defenders, which most offices don't do, and would take some, that would be interesting to try to implement. And I don't know how good the data would be, but anyway, I mean, there could be a state study and there could be some interim measure that's just less extreme, but that's not what's proposed. Well, I mean, there may be people proposing these alternatives to the Supreme Court, and I expect they will be when the comment period opens. But it's hard to propose something that has nothing to back it up, I guess. And that's why the RAND study has carried the day, because it does have that recognition, and it's been peer reviewed, and, you know, so it's kind of hard to say that it should be anything but that.
Thank you, Maya. I believe there's an individual with their hand up in the conference room. Unless
It's
that's
Peter.
you, Peter.
Yeah,
Sorry.
it's Peter Fraser.
Okay.
Maya and Eric, I'd love to hear more detail about, if you have any kind of rules of thumb around, Maya, what one of your defense attorneys, what sort of how much support they have. I can imagine that you would, for every defense attorney, you need to bring on.
Yeah.
Yeah, and then space. I'm just kind of looking at the overall cost and trying to get an idea there. And then Eric, I'd be very interested in what how this would affect your office.
Yeah, I was just talking with one of his deputies about that this morning, but the ratios currently are one attorney, one legal assistant to 4 attorneys, 1 investigator to 4 attorneys. And there's no standard that discusses a mitigation specialist or behavioral health specialist, but we are lucky enough to have 3 who each have currently 9 attorneys. The standards as proposed would change those in the last year of implementation. So I don't know, what year is that, Raylene? 2028? I don't know.
27.
Okay, would change those ratios to 1 to 3 for investigator and behavioral health specialist, leaving at 1 to 4 for legal assistant. So it would mean increasing not only just increasing because of additional attorneys, but the ratios are tighter for investigators, and it would add quite a few behavioral health specialists. I mean, we would need like a fleet of social workers. We need a fleet of social workers in our office. I don't get me wrong, we need them, I think, but we would need a fleet of them, and that would require. I mean, I supervise the 3 behavioral health specialists we have right now. You know, like I'm not trained in social work. I don't have a master's in social work, and they do, or a couple of them do, and I'm supervising them. And I mean, I know what we need as attorneys, but they would probably be better supervised by a social worker, who maybe then reported to me, you know, who kind of has more knowledge, more of their specialty knowledge. Anyway, so those are the ratios. Yes, it has those rippling effects of even more staff needed. And just as to, I mean, Eric, you know, the prosecutors don't have standards, and I think those would need to be created by maybe WAPA and then present. I know, like, I don't know what the movement is there, but, you know, if we having a much larger public defense office that doesn't have a likewise increased in personnel prosecuting attorney's office, I don't know how effective that's going to be. And that I need the prosecutors to set up interviews in many cases. I need them to be responsive to requests for discovery, responsive to motions. I mean, when you've got 5 defenders with doing the work of 1 prosecuting attorney, their responsiveness is, you know, it's just it'll slow everything further. So there has to be some degree of parity there. I think the work we do is very different than the work that the prosecutors do. We have to do investigation. We don't have law enforcement as our agents to do work, or we can't direct law enforcement to do investigation for us, you know, so we have different needs and our work is different, but the ratios have to be closer than they would be with these standards.
Yeah, so Peter, that's a good question. How will this impact the prosecutor's office? I think it's going to impact us greatly. You know, presumably, if there are more public defenders, there will be more work needed by prosecution and courts. Don't forget the courts. We haven't talked about them yet. Presumably, there'd be more trials. Because people would be challenging things more readily, such as, you know, motion practices or trials. Boy, I don't know. It's complicated to really know how much. I mean, Maya was talking about having some sort of parity, and we currently don't have parity. Right now, the public defender has more attorneys than the prosecutors. And then you add in the conflict attorneys that Raylene is overseeing. There's even more. And then you add in private attorneys, and guess what? It's even more. You know, we're probably outnumbered 3 to 1 right now. And you add in more public defense, and it's just going to be way, way out. I guess a little more detail about your question. You're asking how much support people we have. Well, we have about 3 attorneys to a support staff person. We have 4 attorneys to a victim witness person. You know, people to help organize some things with victims and some of our evidence. And you know, they'd need to be increased too if we were to increase our prosecutors. You know, I'll just say that it'd be crazy not to increase the number of prosecutors if we're going to increase the number of public defenders the way that's being suggested. I don't know what it's going to look like, you know, and I don't know where the money's going to come from. I don't know where we're going to be able to put courtrooms. You know, you asked about space. Where are we going to put attorneys if we can find them? I don't know.
I think
It's really kind of shocking, this change that's suddenly happening. And Maya mentioned about organizing and standards. We don't have standards within prosecution. Public defense has standards because they have there's a constitutional requirement to you know, a good defense. There's not a constitutional requirement that the victims have adequate support. There's not. I mean, there is some statutory authority for that, but it's not constitutionally bound. should it be? Maybe. What do we do? We probably have to be looking at keeping things a little bit more on par as Maya suggested. That's all I have.
I think it's like, I think a movement like this that's really looking at examining, it requires us to examine the criminal legal system, and it could push us to really look to diversion and look to probably charging offenses that are currently charged as felonies as misdemeanors, which I understand Darlene would push burden to municipal courts, but I don't, but that is a way to cope with some of these standards. And then in district court, while technically misdemeanor attorneys can accept up to 400 cases a year, we do not. Our attorneys, our misdemeanor attorneys do not handle 400 cases a year. That is an insane number. I don't think anyone thinks that that's possible. We keep them at 200 or below because it's not possible to do what the standards suggest right now. So the staffing changes in district court or municipal court may not be affected as extremely as the felony standards. There would be they would be impact, but there would be less. And so I think it's like we really have to commit to developing diversion programs and ways to keep people out of the criminal legal system to reduce the number of cases coming in and deal with the serious cases, like the $10 shoplift burglaries. This person's got 10 of them, 20 of them, they could go to prison for a long time if they're convicted of that felony. But is that really what we're trying to do here? It's like, how are we addressing? I don't know. So I think it just requires re-examining where we're going, I think.
Yeah, I'll agree with Maya on all those things. Every single point she made. But one other thing that might happen that might help this whole system would be to change the requirements for those who are receiving public assisted attorneys. It's being looked at right now by our administration, I can tell you that. We have people that get public defenders and actually have full-time jobs, and there's a question about whether they should be given a public defender. They never ever get required to pay back services, even if they're found to have a full-time job or lied on their application. It's virtually impossible to enforce or to I guess get refunds for what's been given to them.
Thank you for that, Maya and Eric. And Darlene has another comment, but I just want to back up a little bit to kind of give you a picture. Currently in Superior Court, we have 4 judges and 5 commissioners. And the 5th judge was approved and signed off on. So we're going to be getting a 5th judge this summer. We're trying to figure out where that judge is going to work in Whatcom County. Where are we going to create chambers? Where are we going to have a courtroom? As we're currently trying to make sure Angela Anderson's courtroom is ADA accessible. She's working in Judge Freeman's courtroom. Judge Freeman is working around that, and we're shifting places that used to be conference rooms into courtrooms, which really aren't set up to be courtrooms. So we're dealing with overflow. I'm sure that Jake and Bruce can also talk about the increase in trials, not only in district court, but in Superior Court. We're seeing more trials going. And so even before these standards may or may not go into place and may be impacting us, we already have a problem with not finding enough attorneys and not having enough space in the county, not having parking for staff, for juries. And so we've got this already complex issue that is now being compounded, and trying to figure out the resources and the funding for it is going to be a big challenge. But I'm going to go back to Darlene now.
I was just going to say just a couple more things to throw in. first of all, small cities, we don't get any compensation for our judges. District court and superior court get state help to pay their judges. We don't get any with the small cities. And so all that burden falls onto the cities. And so that's something to take in mind. The other thing I would take in mind for instance, the city of Bellingham, since I've been here for the last 10 years with the city, 75 to 80% of our cases, the defendants are indigent. And every single one of those clients has to verify that they're indigent. For the city, we don't take their word for it. They have to prove, they have to show us they're on subsistence, or they have to show what their income is. And then occasionally a judge will appoint an attorney, but they will, if they have any kind of income, they will usually ask them to contribute a few $100s to their defense. But the rules for helping indigent folks have gotten, the legislature has been leaned more towards helping them than having them pay, which is only fair. So if you take that 75 to 80% of our cases have to have a public defender, I think it's also going to be an issue of prosecutors in the lower jurisdictions having to take a look at cases too, and coming up with more alternatives for some of the lower level offenses. Because as we're seeing folks want people in the downtown corridors and so forth to be held more accountable, that means more arrests and more people that need public defenders. And somehow there's going to have to be a balance of what actually ends up as criminal charges and what our public defense can handle.
Thank you, Darlene. Bruce, and then Eric.
I just wanted to add to the comments that Darlene had just made about state support of judicial officers. So the way it works in Superior Court and District Court is different. My understanding was Superior Court, and I don't want to be the spokesperson for Superior Court, but the state pays a percentage of the judge's salary and benefits. The state does not pay directly the salary or benefits of the district court judges. That's entirely 100% local county money. However, the district court judges, I'm sorry, I phrased that incorrectly. The county is able to be part of the disbursement of the trial court improvement account funds because of the judicial officers that we have, and we have 2 of them. So it isn't a direct reimbursement for salary or benefits, but it goes into a fund that's controlled by the executive branch. And I believe that Whatcom County gets, as a result of that, about $40,000 or so a year, of which the county executive's office controls the disbursement of what it will actually be used to be paid for. So just a little clarification there.
Thank you, Bruce. Eric?
Yeah, so I just wanted to talk a little bit about what Darlene said too, and I know she's right that there'll have to be some sort of diversion programs developed to help out the loads in misdemeanor courts throughout the state. But diversion to what? That's a big question mark. Are we talking about treatment? Are we talking about some community service? And while those things sound great, what is going to encourage people to do anything without criminal justice support? If we don't have somebody holding jail as the reason why someone needs to do something, they're not going to do it. And Darlene, that we can't get people showing up to court in municipal court. I hear about that from Ryan Anderson all the time. Somehow district court's getting some action. I'd love to hear what Bruce has to say about that. But it's been difficult getting folks to be engaged in any sort of diversion program in our county.
Thank you. Any other comments or questions on this topic? Well, I think we want to keep this on the burner and continue the conversation as things change and we see what the Supreme Court does and other impacts that this is going to have. But it is definitely something that can be very costly, not only for Whatcom County, but all the other counties in Washington State as we're all trying to get more attorneys. Heather. I saw her hand. Nope, she went back on mute. Is she coming back?
Sorry, I was just raising my hand to get promoted to panelist to see all of
Oh,
it. Thank you very much.
thanks, Heather.
Yeah.
Did you have any more comments on this topic? Okay,
No, thank you.
excellent. So Heather and Peter and Dr. Safford are here with us today, and I think they want to hear about what they can do to help us in the future. But I'll turn it over to Peter and Heather to discuss, and Dr. Safford, and see if there's other topics that you want to see here with the Legal and Justice Committee, or how you want to assist.
Heather, shall I go first? Are you good? Okay. Well, thank you for this really good discussion. It is one of many over the years. I have not attended this particular committee all that many times, but Bertie and Heather and I are doing a lot of planning for the IPR and reconsidering how we work. We want to lay plans for how we get as much done as possible. We are showing up to all the meetings this month and well into the future to, we'd really like to hear from those of you willing to speak today around what has come before, what has been helpful, what changes that you would like to see, and open, honest discussion about the process of this committee would be helpful for us to hear in our planning. And Heather, do you have anything to add to that with our goals for this discussion?
I think you framed it really nicely. We're glad to be here, and solid foundation to stand on, of course, and excited to have a conversation about what else and what more.
An
Thank-
open and honest conversation right now around process would be really helpful. We have 20 more minutes, is that right, Raylene?
Yes.
Okay, great. And I suppose we need to take time at the end for any members of the public. There aren't any people in the conference room with me, but if we could open it up.
Mike?
Yeah, thanks to the co-chairs on this issue. I mean, I would be interested. I mean, I don't know what level or where this, maybe there's a meeting of the entirety of the IPRTF that we could look at the different committees, determine, and I know you guys are thinking about this, like decide which are overlapping, which have sort of stalled out, maybe aren't needed anymore, and be a little more consolidated in our use of time. I'm always going to say that I object to meetings that go over the lunch hour because it is not cool. It's not cool. Like I need to take a break. Like I need to eat lunch. I need to not be doing work at some point in the middle of the day. And I don't know any union staff. I don't know if they would want to participate in this, but they don't work over the lunch hour, and I'm not union, so I can work over the lunch hour, but I don't like it, and I don't think that it's a good way to have people involved in this. And I know maybe even people have talked about Saturday meetings. Maybe that's a possibility. I don't know what kind of turnout we would get for that, but I'm always gonna toot that horn of give people their lunch hour. Thanks.
Thank you, Maya.
Thanks, Ryan. I
Who would
think,
like to speak next?
right, I think that this group that we have for the legal assistant, a lot of us are currently working. And we've got a lot of different obligations, but it's extremely important to get input from those of us that are actually working in the criminal justice field for the task force. So trying to be mindful of the members of the Legal and Justice subcommittee is important to make sure that we're getting valid input. And if it means adjusting the times, I think that's something we should look at. My other thought is, I had a co-chair. She's now at the Behavioral Health Committee as things have changed. I'd be and love to entertain having another co-chair, because as the steering committee comes up tomorrow, I have 3 other meetings and I'm trying to figure out how to balance all of that and where I need to be for which time, for which meeting. As well as I continually have people coming into my office. So it's a balancing act, but I also think that these meetings are important and I value discussion that could be very impactful for the rest of the county. You see Eric's hand up.
So I wouldn't mind being a co-chair, although I'm not sure that I'm allowed to be based on my position. That's all I have right now.
Jill, can you look into that for us?
I can, I'll look into that.
Thank you.
I can look into that. We've looked into it from my office relatively recently, and I know that it would be appropriate for me to be a chair of this committee, the whole group. Although I'm not sure about being a co-chair of this committee.
Well,
So-
thank you for volunteering, Eric.
Anything in the IPRTF's enabling ordinances or anything like that, Eric, that prevents you from being a co-chair? So my looking into it would simply be asking George if there's anything from your guys' end that would prevent it. So.
Right. I'll holler at him in a few minutes if you'd like.
That sounds great. Thank you.
Yay. Anybody else have comments or questions for Heather or Dr. Safford or Peter?
I'll throw a question out there. Oh, Perry, let me just throw the question out there and then let's hear from Perry. Historically, what has been the most effective use of your time in these meetings? We typically have presenters, we have discussion, maybe some coordination. I'd love to hear more about where the great efficiencies are in the use of the time in this hour. Perry, go ahead.
Thanks, Peter. It was actually along the lines that my thought process was. I think that there is importance that the subcommittees and the larger committee, but the subcommittees particularly, are getting information from programs, in the processes that are sort of going on, updates, so forth, because there are a lot of changes going on. Obviously, I mean, Maya's example today, that there's some very dynamic changes that are going on, relative to the court systems and attorneys and so forth. And I think that that's honestly true I think about the things that I'm involved in, for mental health court, just as another example, recovery court. There's a number of dynamic things that are happening there. And sometimes I hear comments or references at times that it's like, well, this shouldn't, consist of presentations. But I think the IPRTF and subcommittees have a responsibility to be informed and updated. So I offer that. I think that there's great value in it. I do have people come to me at times and say, why don't we have a chicken in every pot? And I really appreciate the question, but it does require, some of it's very sophisticated. And, we have to have a discussion that there isn't typically a simple answer for something. And again, I think the information, exchange is really important, but I certainly consider myself responsible to be more informed as a subcommittee and as a IPRTF member, because it's not just, we heard it from them, a year ago or 6 months ago or whatever, and so we know about that, and it's like not necessarily. So anyway, I advocate for those presentations. I certainly benefit from them. And I'm aware of the dynamic changes that occur in them oftentimes. So I wanted to offer that up.
Thank you, Perry. Stephen, do you have any observations in your time?
Well, I'll speak to your question, Peter, about process and build on Perry's comment. I certainly have always appreciated the presentations and the information and the updates and the problem identifications that we traditionally have. My own view is that we've gravitated a little too much to that, to the exclusion of any efforts to develop responses to the information we have, recommendations to various stakeholders for steps that we could promote. And the other thing that gets lost is any ability to research best practices in the areas that we're talking about. So I don't know if that takes the form of subgroups of the committee to work on proposed action steps, but I think the action step piece of the work of the committee and the task force has been missing here and in the larger group for quite some time. And so I would look at ways to reinvigorate that side of the picture.
Dr.
Thank
Safford.
you, Stephen.
Yeah, I was just curious on the issue of presentations and how to balance that with committee time. Do any of you have any ideas on possible alternative ways to get some of the information in the presentations rather than the whole committee gathering at a particular time to hear it? Do you think summaries or recorded things to do offline or any other way that would help us get back more to the balance that Stephen's talking about? So I just wanted to raise that issue.
Just to comment on that, I don't disagree with Stephen on trying to need a balance for those areas. I guess when we have a presentation, we need to come up with some forethought. Why are we having the presentation? And what is this going to do, or how are we going to promote? What is the outcome we want from having the presentation? And then how do we bring that forward? And is that something that can be done in that meeting? Or is, okay, we've had the presentation, and then do we have another meeting to discuss what came out of that? Where are we going with the presentation? So as we discussed today, public defense standards and the impacts that are gonna happen, I guess, I'm looking at, okay, say the Supreme Court adopts these. Maybe they do, maybe they don't. Now, what are we looking at? There's going to be a public comment period. Is that something that the task force as a whole will want to address and have any comments towards, or individuals that have watched these presentations? So I think that's when we have a presentation and then we bring what's been discussed in the subcommittees to the task force as a whole or through the steering committee, then it needs to be addressed on, okay, this is what came out of it. Does the whole task force want to pursue this? What are the outcomes that we want from the presentations? And maybe having more direction on why are we doing the presentation and what do we want from them?
Is there anyone who hasn't spoken who would like to comment? And let's Perry, let's hold off for just 1 second. Okay, Perry, go ahead.
Yeah, just following up on Ralene's thoughts there, I would tend to agree, and possibly even a template for subcommittee members of, you know, again, what is our goal? I think that it often occurs, but engaging the presenter relative to, so what are the challenges? What are the barriers that you're experiencing, even if you don't have necessarily answers of, and what should we do about that? But my point being that we could make that a bit more uniform. And I know as a subcommittee member that this presentation is going to occur. And again, I have this really brief template, in regards to why are we having this presentation and et cetera. So I think it's a really good idea to orient the subcommittees to the concept.
Very good.
Stephen.
I'm going to weigh in suggesting that my experience is that the process seems more productive if recommendations are developed in the committees and forwarded to the task force, and they are the focus of the task force discussion. I haven't found open-ended brainstorming kinds of discussions in the task force quite as productive. They certainly don't include all the members of the task force, many of whom don't speak up for whatever reason. So it would be helpful to do some shaping work, some formulation work in the subcommittees. And sort of a sidecar to that comment is in regard to Perry's advocacy of some sort of template. One of the templates that we've adopted and then pretty basically uniformly ignored is the template provided in the racial equity toolkit for decision making that makes sure we are inclusive and considering matters of equity and so forth in our deliberative process. So to the extent that the committee thinks in that way process-wise or adopt some sort of formal template, I would hope we could incorporate the questions. That they're 6 questions. They're pretty meaty questions, and they'll take more than a couple minutes to work through. But I think it's really incumbent on us, especially after the discussions we had last year in the campaign, to make a formal and on the record focus of those questions.
Thank you. Maya and then Heather.
Thanks. Just as to the comments on the standards, it's complicated because I imagine that, you guys know there was the WASAC lawsuit that was dismissed about state funding, and I imagine that the exec's office is going to have a position on this and will be doing some advocacy, and I don't know what that will be. And so I don't know what the position is going to be of the county, and I don't know that it will be I don't know. I just see there's potential for a great deal of conflict and different positions, and I'm not sure. I don't know. It's just going to be complicated. So I don't know that the IPRTF, I don't know if we're the appropriate body to be making comment on it. I don't know. That's all. Ideas.
Thank you, Maya. Heather, I don't know if you took your hand down or if it was up and then I saw Eric.
Eric, do you have something in response to Maya? Mine's a different topic, so you can go ahead.
Right, thanks. Yeah, so I think that the administration and essentially the county is going to be concerned about the costs, and that will be the direction that any sort of lobbying or comments will be made. I know that the public defender frankly, Stark and and Maya, you both might have different thoughts about this. I know that Stark has supported the idea that cutting the way the Bar Association has recommended is too much. And I'm not really sure, you know, how the rest of the public defenders feel about that, but I know that's Stark's position. I believe that we don't need to be unified if we're to make comments. I think that we can make comments without unification, and I think it'd be appropriate to do so, considering all the factors that we know.
I tend to agree with Eric on this, and the reason being is it's going to become very costly when we look at if these changes are implemented and accepted by the Supreme Court, what are we going to fund and what are we going to cut? I mean, because unless this is funded, if this is approved and we don't get state funding, you know, I'm supposed to have so many clerks for each court hearing, for each judge, and prosecution is needed, and judges are needed, and support staff, and all of these things cost, and we have spatial needs. And when we get unfunded mandates, it becomes very difficult to do the job. And so those are things that we can say, yes, you guys are going to do what you're going to do, but make sure we're funded adequately so we can actually grow, so we can do the jobs that we want to do, because we want efficient and effective counsel for everybody that has a right to it. And those are concerns that we can look at. How do we do that with neutrality in mind? Anyways. Heather.
Yeah.
Oh, sorry, Maya.
Just because it's still on sort of that subject, like there may be litigation where we end up in a situation that's similar to True Blood, where there's contempt hearings and we're getting contempt rulings against the state for not paying, and you know, it's like there's a lot of different ways that this could play out. And so I think when we're looking at there maybe litigation like that, then it does become really complicated on putting out positions and making recommendations. That's all. Thanks.
Thanks, Maya. Heather, I think you were up and down and up and down.
Yes. One thing that Peter and Bertie and I were doing also was looking at the original statements of work and scopes of all of the subcommittees. And I'd love to bring that back maybe to the next meeting to review and refresh. I have it up on my screen and it is on the IPRTF website, but in terms of a screen or a lens for bringing presentations to committees, I think it's a nice thing to measure against. Is this for our stated goals? And I'd love to get us to a place where our goals are really visible and that we're tracking progress on them. And so like the statement of work says, the purpose of this committee is to recommend to the task force specific achievable programs and services that would prevent or reduce incarceration if implemented within the legal and law enforcement systems. And then there's 6 goals that range from evaluate the alternatives to incarceration which currently exist in Whatcom County, compare those to recognize best practices and recommend improvements, all the way to really specifically recommend discharge planning procedures, which will help people who are leaving incarceration connect with and engage in community and behavioral health services available in the community. So I think it's a nice grounding document to look at kind of what is our progress, what are our goals for the year, and then what topics need to come to the committees to make sure that we're making progress on all those goals. And I haven't been attending these ones consistently over the last couple of years, so maybe you're already doing this in some way, shape, or form, but I'd love to bring that back at a future meeting for a longer discussion.
Thank you, Heather. I think all of your comments have been very helpful today, and I appreciate everybody. Unless there's somebody else that has a comment, I'm going to move quickly to other business and then public comment. All righty. Does anybody have any other business? No. Okay. Jill, can we open it up for public comment?
We can open it up for public comment. Peter, is there anyone in the conference room besides yourself?
I'm here by myself.
Okay, thank you.
Okay, Jill, was there anybody attending virtually?
No.
No, okay. Well, thank you, everybody, for your attendance and participation in today's committee meeting. It is 12:32 and I'm calling it adjourned. Have a great day.